Ready for the dictation? Important matter for all the upcoming High Court exams. Ready? Start. Taking into account the order passed by Division Bench of Patna High Court in CWJC number 74 of 2016, wherein the Patna High Court, by taking into consideration the provision of Section 88 within bracket 1 of the Motor Vehicles Act 1988, has quashed and set aside the impugned decision of the authority with a direction upon the concerned respondent not to realize the tax from the petitioner for the period the permits were not countersigned. Learned single judge of this court allowed the writ petitions directing the respondents not to realize the taxes from the petitioners for the period the permits were not countersigned. Full stop para. Mr. Rahul Kumar Gupta, learned senior SC1, appearing for the state appellant, has challenged the order passed by the learned single judge inter alia on the ground that the writ petitioners are liable for making payment of tax since the permit granted in favor of the writ petitioners were renewed up to 2018, and accordingly road tax was fixed, and when it was not paid by the writ petitioners, rightly notices were issued to them for making payment of the road tax, but without taking into consideration this aspect of the matter, learned single judge has set aside the order. Stop. Hence, the impugned order is not sustainable in the eyes of law. Stop para. Having heard the learned counsel for the state appellant, and after appreciating the grounds agitated in the present memo of appeals, as also taking into consideration the findings recorded in the impugned order, this court has found therefrom the admitted facts to the effect that the writ petitioners were granted road permits, and in course of its subsistence, by virtue of bifurcation of state of Bihar, the permits became interstate, which were renewed up to the year 2018. Stop. The writ petitioners moved before the respondent number 2, State Transport Authority Jharkhand at Ranchi, for its counter signature for the period between 2013 to 2018, upon which the State Transport Authority Jharkhand issued direction upon the writ petitioners to pay taxes with effect from the separation of the state of Jharkhand before the taxation authority in terms of the provision of section 3 of the Act 1994. Stop. The said decision of the State Transport Authority fell for consideration before this court on being assailed by the writ petitioners, wherein the learned single judge has taken into consideration the order passed by the division bench of the Patna High Court in CWJC number 74 of 2016. Stop para. This court has gone across the judgment rendered by the Patna High Court passed in CWJC number 74 of 2016, wherefrom it transpires that the Patna High Court has taken into consideration the provision of section 88 within bracket 1 of the Motor Vehicles Act 1988, basing upon the same, it has been laid down therein that the liability of tax under the Taxation Act would therefore arise from the date of such countersign as clearly provided in section 14 of the Taxation Act, because only from the date of counter signature, the interstate permit issued by the authority from outside the state of Bihar would be valid within the state of Bihar. Stop.